If you have any criminal history at all, guessing whether you need a visa lawyer is one of the most dangerous mistakes you can make in US immigration. Hello, my name is Lara Akinlude, and I'm the managing attorney at Lardell Law. If you're applying for a USB 1/B2 visitor visa and you have a past arrest charge or conviction, even if it was years ago, this video is essential. Today, I want to explain when criminal history means you should speak to a visa lawyer before applying and why getting this wrong can have long-term consequences. 1. When criminal history becomes a legal issue. Not every offense creates a problem, but some do. You should seek legal advice before applying. If you have any arrest or charge, even without conviction, any conviction involving theft, fraud, or dishonesty, any DUI, especially with aggravating factors, multiple offenses or repeat incidents, any uncertainty about how to answer the DS 160. If you're unsure, that uncertainty itself is a red flag. 2. The risk of applying without legal advice. Many applicants assume it was minor, was a long time ago, it was expunged. Unfortunately, those assumptions often lead to immediate refusals, findings of misrepresentation, long-term or permanent visa bans. Once a mistake is made on a US visa application, it can follow you for life. 3. Misrepresentation is often worse than the crime. One of the most serious findings in US immigration is fraud or misrepresentation. This can happen when information is omitted, questions are misunderstood, answers are guessed rather than confirmed. In many cases, applicants are refused not because of the offense, but because the offense was handled incorrectly on the application. 4. When a lawyer adds real value. A visa lawyer does not hide criminal history. Instead, they help assess whether the offense triggers inadmissibility, determine if a waiver is required, present the facts clearly and correctly, prepare you for interview questions, avoid permanent mistakes. Legal advice is about strategy and protection, not fear. 5. Timing matters more than people realize. Applying too early before understanding your legal position can cause irreversible damage. In some cases, waiting, gathering proper documentation, or applying with a waiver is the difference between approval and a permanent refusal. 6. A simple rule to remember: if you are asking yourself, do I need a visa lawyer for this? The safest answer is, I should speak to one before applying. Having a criminal history does not automatically mean you cannot travel to the United States, but applying without understanding how US immigration law treats your history can close doors permanently. If you have any concerns about past offenses and want clarity before applying for a B1/B2 visa, speaking with an experienced US immigration lawyer early can protect your future travel options. At Lardell Law, we help clients assess risk, understand their options, and move forward with confidence and clarity. Thank you for watching. And that brings us to the end of this B1/B2 visitor visa video series.